All right, good evening, everyone, and thank you for attending tonight's board training. Before we get started, I just want to take a moment to thank all of our board members for being here tonight and volunteering and to serve your communities and the opportunity to partner with you. I would also like to thank our Diversified team. We have Kelsey and I here tonight, but there was a lot of people from our team behind the scenes who helped put this presentation together, so thank you all. A few housekeeping items before we get started with tonight's presentation. All the guests in the presentation will be muted. If you do have a question, you can use the chat feature and ask any questions. Our office manager, Brittany Murray, will be answering any specific questions that she can that come up throughout the presentation. We will also be having a public Q&A portion for the last 15 or 20 minutes of the presentation to answer any questions, frequently asked questions that are coming up throughout the presentation. So that'll be at the end of tonight. If you do want a copy of the slides that we've presented tonight or the recording is being recorded tonight, you can reach out to your community manager who would be happy to provide that. Hi. Did everyone hear me? Okay. Sorry, we didn't know if we were muted. Hopefully everyone can hear me. For those of you who don't know me, I'm Casey Martin. I am the Vice President of Operations at Diversified. I've been with Diversified for 6 years. And this is Kelsey Knudsen. She's our Director of Community Management. She oversees our community managers and is a big part of your community's success and ensuring well-maintained communities. We also have the pleasure of introducing Tim Moeller and David Graf with Moeller Graf. They have really been a huge part of us navigating these new laws over the last few months and really are a huge resource in the industry as a whole, but we're excited to be with them tonight and to partner with them.
Absolutely. Thank you guys for being here. We
Well, thank you for having us. We've got a ton of people on here. It looks great. We got a huge crowd. So thank you for, I think you can probably hear all my beeps going off on my computer, but thank you for all being here on a Monday evening to want to hear about this this new legislation that came about and that's caused a lot of changes, a lot of administration, extra administration that's probably going to cost associations more money to implement. But let me first introduce myself and David Graf. I'm Tim Moeller. David Graf is my law partner. Our firm is called Moeller Graf. There's 9 attorneys total. We have an office both in the south part of Denver, as well as in the Springs off of Interquest Parkway. And we only represent community associations. That's all we do. We represent hundreds of community associations throughout the state of Colorado. Dave and I started our firm 17 years ago, but I've been practicing community association law solely for 23 years, and David's been doing it for almost that same amount of time, as far as representation of community associations. So this is all we do. We are pleased that you guys would have us here tonight and to help our wonderful team members at Diversified provide some information to you.
And we have a lot of information, so we better get going.
Yeah.
Lots.
We'll take it as that. So we're just going to give a quick little overview of what we will be discussing tonight. So obviously Moeller Graf will be discussing the fine-tooth details of the new 1137 bill, and then Diversified will be navigating how the new laws will be affecting your communities and ensuring that we are compliant with that. And then we're going to be giving some trends and tips that we've seen since this new law has went into effect as of August 10th. So I will pass the baton over to Moeller Graf. Thank you, Dave and Tim, for taking the opportunity to educate us on how these new laws are affecting every single one of our associations in Colorado.
Awesome. Thank you. So this is an interesting bill that took effect on August 10th, 2022. We call it is named House Bill 1137, but primarily affected the Colorado Common Interest Ownership Act. And it started in the HOA that Tim Moeller and I live in. Not many people know this, but there was a foreclosure brought against a big firm lawyer, and he felt that he didn't get any notice, and I don't have any reason to doubt that. And he wrote the bill, and he got a sponsor to introduce it. And then when the bill was winding its way through the legislature, then the Green Valley Ranch news stories hit the press about people being foreclosed on for covenant violation fines and all these foreclosures that are disproportionate to one community. And to everyone's surprise, the bill had the votes then to pass. So it's primarily a collections and covenant enforcement limiting bill. And like I said, a House bill is the HB 1137, but it is part of the Colorado Common Interest Ownership Act. Do you want to move? Thank you. So there's limitations on the board's power to act. There are additional procedural requirements. As you know, you've had to get new policies for collections, covenant enforcement, and meetings, conduct of meetings. These are big changes. It's the most industry disruptive bill that I've seen in 27 years of practicing law, not because the people who sponsored it were evil or ill-informed. There are things that the bill was designed to address, and there are a lot of things that the bill leaves to the imagination in terms of what we have the authority to address as community association professionals. And I think that's most of the heartache in trying to figure out, okay, what does this mean? We know that we have to revise our policies. We know that every management company that represents communities had to change all of their policies, their form letters, their internal procedures. Some had to make software changes to comply with the new law.
Some had to hire additional bodies for all the certified mailing, things like that.
Yeah, it's been a bit of a challenge. And I had hair before the bill took effect, and here's where I am now. Do you guys want to advance the slide, please? Do you mind? So one of the key issues, and the intent of the legislature on this issue was to be more assured that we had notice going to the owner that their account was going into default, that they were delinquent. And so what they said was, before you send the case out for collections to an attorney or a collection agency, you must have first contacted the owner, given them a letter with specific magic words in the letter and in your policy as required by statute. You also have to keep records of contact with the owner. And so what that's done is it's created, obviously, a bottleneck in terms of collections, because associations have been struggling to get these letters appropriately handled on a process that can be replicated. And there's a number of good points in the bill, and I don't want to sound negative. One of the good points I think in the bill was the bill allows an owner who's delinquent to designate a contact that the association can then speak to this person about the delinquency. And this has been going on forever. When someone is delinquent and they don't speak English, perhaps as their primary language, having a family member or a friend who can translate has been super helpful. And that's one of the very bright spots, I think, in the statute. What it does, of course, though, is obligate the management team or the association, if it doesn't have one, to communicate both with the owner and with that designated contact. From where I sit, it's a little bit more work, but we do find that the owner is better able to communicate. Now, on the topic of communication, what the statute also says is that if the owner requests the association speak to that owner or correspond with that owner in a specific language, then the association must do that. And the statute is silent on whether or not we can charge the costs of translation back to the owner as a consequence of that delinquency. It's a little bit outlandish to me that associations would have to hire a translator to correspond with people in languages that may not be spoken. There's no limit on the language, and there's no requirement that the person requesting it speaks that language. So when I get really feisty, I'm going to request that all of my HOA notices come in Welsh, and while I don't speak it, the statute will require that they translate that. I haven't seen it been abused yet, so I'm not really that worried about it. But part of the reason I don't think it's been abused is because of the delay in collections, the collections process, by virtue of trying to get everything up to speed to comply with the new law. It has the potential for abuse, and there's scuttlebutt in legislative circles about maybe narrowing that back to a few languages, not including all, Klingon, Welsh, and other languages that may not be in common parlance. We do now have to send delinquency notices, certified mail, return receipt requested. That's what RRR means. Last I checked, that's about $8.50 per piece, just actual cost of mailing. And quite frankly, certified mailing, in my personal opinion, only proves that the owner didn't get it. We usually like to send things certified mail if we have to, but we always try to send things regular mail. The certified mail comes back unclaimed. The regular mail rarely comes back. And I think that may be slated for a cleanup just because of the cost relative to the certainty that it's getting there that certified mail does not provide. One of the most interesting things about the bill is that the association must post what we call a notice of delinquency on the unit owner's unit. That's what the statute says. The notice of delinquency has to be posted at the unit. No provision for when it's a rental. We have communities that have vacant lots. They're putting up little signs with the delinquency notice posted on a sign because there's no provision for common sense in this. I find that this provision of having to post delinquency notices at the unit is the most customer unfriendly part of the bill, because early in the collections process, someone's going to go onto the private property of this owner and tape something to their front door. Right now, where people are, they don't appreciate that, and it's nothing that we can control. It's mandated by statute. You also oh, go ahead.
It's also pretty expensive to get somebody to spend the gas money to drive out there and to post the thing and to take a picture or write it and create an affidavit or something, whatever they're going to do to prove that they did it. We're finding that a lot of process servers or sometimes ex-law enforcement or things are doing that, and they're not inexpensive to get this done. So that's another added cost right off the bat. That's the first contact made with them in many cases. And so it's a bad customer experience.
Yeah, the law doesn't prevent us from sending courtesy notices, and I know Diversified is smartly obsessed with how do we create this customer experience, because if we rile up all the owners unnecessarily over a $42 delinquent balance, that doesn't bode well for the association's health. And that's been one of the conversations we've had, is how do we get courtesy notices out so that people are politely informed on an escalating scale that the account is past due, without having to rush out there and send people with zip-tied handcuffs and a bulletproof vest onto their front porch. We also and I've had complaints from communities where people are like, hey, you just sent a bounty hunter with a headlamp and a gun and a bulletproof vest, and it scared the living heck out of my family. It's not appreciated. And it's actually required by statute. We also have to contact the owner in addition to regular mail and certified mail return receipt requested, text or email. We get to pick, and that was designed to give us some flexibility, but we don't usually love texting people. So be careful with that. And that's a heavy lift for the management team. That's not usually things that the boards have to worry about. We just want you to know that it's requiring us and the management team members to do things that we haven't done before, using software that wasn't designed to keep track of those types of contacts. Additionally, with respect to the board having to do something additional, the statute currently says that you can only refer a delinquent account out to collection, meaning to a collection agency or to a law firm, if a majority of the board votes in an executive session to so refer it. Now, prior to this, you could have had a collection policy that says if someone hasn't paid an assessment in 90 days or the statement balance is in excess of $500 or $1,000, it's automatically referred out. Here you can't, and you'll have to vote on each one individually. We send out a template 4 minutes for that and a resolution for the board to sign, just so that we have the record keeping of that. But that is an additional step that boards will have to be prepared to handle. So there's collections and covenant enforcement is a little bit intertwined, because there's some limitations on your ability to fine people for covenant violations. We'll talk more about covenant violations in a minute. One of the notable issues is that you can't charge interest on a delinquent account in excess of 8%. Prior to this, it was capped at 21 or whatever the declaration specified, if lower. Statutory now it's 8%. And I've had some people say, well, I'll just let my balance accrue at 8%, right? With interest rates, why should I pay my assessment on time? I don't think most people are taking that position, but 8% is something that, you know, we don't want to profit from people's delinquent balances, but we also want to have reasons why people would be encouraged to pay in a timely manner, because your insurance premiums as an association board, as you know, have to be paid on time. They do not take installment payments in many cases. So we have to give, and we'll talk about a payment plan. We can't.
Dave, if I can just go back really quick, that cap of 8%, many of your documents are going to say more than that, right? A lot of them are going to say 21% or such a, you know, percentage as the board may determine by policy or things like that, or it'll have some other percentage. It doesn't mean that you have to now go and get a 67% vote and rewrite your declaration and things like that. It's just know that it's capped at 8%. That's what your policy will say, because that's mandated by statute. So don't think that now your entire declaration has to be rewritten because it's illegal. It's just been overridden by this provision. Sorry, yeah. Next one. Sorry about that.
Chat. Okay, so we'll have to offer someone a payment plan. We'll talk about that more in the foreclosure context, but it's not limited to foreclosures. Don't want to steal any thunder, but it's an 18-month payment plan, and it allows the owner, I think, to pay $25 a month for the first 17 or 18 months. And there's no exception for special assessments or insurance deductible assessments. It's a problem, and I think that's needing a change, because we have communities with deferred maintenance, or they have a hail claim on their roofs and they have $1 million insurance deductible that has to be apportioned across all the units. And if 10% of the owners decide to pay it $25 a month over 18 months, that roof is not likely to get put on. And so that's something I think that needs to be addressed. And if someone has a payment plan, which they have a statutory right to, they're not off of that payment plan unless they miss 3 monthly assessments. So that's also a change. And we'll see how that plays out. Like I said, we haven't had enough collections subsequent to the passage of the bill that we have good data on how that has shaken out, but it has the potential to be a significant problem for associations.
Yeah, it's a cash flow issue.
Just to add to that, Dave, you know, we do have some of our communities that are going through special assessments, and in that particular situation, it's important that you're collecting the money, whether it's a big project, big deferred maintenance situation that, you know, you need the funds to be able to keep the project moving forward. So that's already been a question that has come up of, okay, if we're allowing 18 months and we're putting out a special assessment to collect these funds to be able to start a project, you know, it makes that a little bit more challenging.
That's a really, really nice way to say it. I mean, listen, if you bought a cell phone and didn't pay the bill, your service would be turned off. If you buy a car, you're not going to get 18 months to pay $25 a month to keep the car, right? The government has mission critical services infrastructure that it provides. They have a super priority lien above our lien in Colorado law, right? Associations taking this over 18 months, particularly for a condo or a townhouse community that maintains building exteriors, it's just untenable. It's just beyond the pale. And I think that was just a miss. It was a miss. Okay, one of the things that I think is not insane, and I'm being a little sarcastic, but one of the things that the statute requires is for any time an account is in delinquency, meaning anytime there's a past due balance, not just to collections, the management team has to send out what's called an itemized list, and that itemized list has to categorize the balance that the owner owes to the association, and it has to be sent every month. And it's not the end of the world. We've had some management companies that have had to retune their software and run specific reports so that it itemizes the past due balance. But what the bill missed, I think, is that when it's been sent out to an attorney or a collection agency for referral for collections, there's a disconnect between fees that we bill and the amounts that the management team has. And this is something that's being talked about in terms of a possible cleanup. But even that can become unwieldy when it's in an attorney's office for collection, because the management team is about 30 to 45 days behind on the true balance on that account. Okay, so again, before you send it out for collections, certified mail, return receipt requested, tell them what the balance owes. And the letter, this notice of delinquency, which is the primary letter that would be sent, although it doesn't have to be the first one, has to have threats. I mean, we don't have to threaten people like we're going to take your firstborn, but it said we have to list the things that we might do to them. And it can't include putting people on the rack and thumb screws. But it's a scary letter to list all of the potential permutations of the collections process to someone who's just had a couple of polite courtesy notices, and they get this letter taped to their door that says you might be foreclosed on, we might sue you, we might do that. And it's taken away our ability to escalate this collection such that there's some management of the customer experience. And I know boards are like, we don't want to manage the collection, the experience for the homeowner unnecessarily, but we don't want to rile up our owners for no good reason. We want the money, but we want it to be peaceful and I think less abrupt than the statute is forcing.
Well, and outside of the board members that are attending this, right, the general membership, they don't know this law passed. They don't know anything about it. And so they start getting this stuff and they immediately blame it on either the manager or the board, right? How dare you send this threatening letter and send this, evil looking person to come put it on my door while my kids were inside, right? So I think that's some of the stuff that you'll be dealing with as board members is, maybe some of that aftermath, not knowing that we're absolutely required to do that as an association. We don't have a choice. So just be prepared.
Right. So talking about being prepared, let's talk about how the collections policies are working here at the Diversified office. So with the 1137 new law, we at Diversified have drafted new policies on behalf of the associations to be in compliance with these new laws. So both collections and covenant enforcement policies. And if you have any specific questions, please refer to your regarding this. Because the new Colorado law requires additional oversight and cost to that. So we have taken a lot of time to make sure that every single one of our associations are in compliance with the new laws. And that's why we have drafted these new policies. And I just want to reiterate that we have found some trends, tips, and best practices over the 8 months since this new law has been into effect. So we just want to remind the boards to treat everyone fairly. You can't treat your neighbor that you're friends with differently than you would your neighbor 3 doors down the street. You can't treat a board member differently than you would someone else. And a part of that is not giving personal phone calls to any of the homeowners or informal emails, because a year down the road, if you gave that additional bit of customer service to one homeowner and you didn't do that to the next homeowner, that could lead to litigation for your association because you're not treating everyone fairly. So we advise against that, just because we advise every single association to follow their new covenant enforcement policy and collections policy.
And these are really real things that are coming up with these new laws. David and Tim spoke to it, but they're very rigid, and they require certified mailings. And in our experience, homeowners feel, like we're taking things too far when things are so rigid, and we lose the human aspect of it. And so questions are coming up. Why can't I just pick up the phone and call my neighbor and have a reasonable conversation? And as much as we encourage being reasonable, there are specific things in the law and in the policies that require record keeping for the association and require a very formal process that we're trying to navigate ourselves. So there's a balance, a balance to all of it.
What Casey just said is there has to be the record keeping aspect of it. And if a board member is shooting a text to his neighbor, we don't have the capability of tracking that to make sure that your association is in compliance with these new policies. And our job at Diversified is to protect every single one of the board members in the association.
Yeah, Carmel has a great comment in the chat, which is, can we send a letter to the owners telling them that there's a change in the law so that they're aware? Sure, we can. We have, one of the things, so there's a balance here, which is, do we tell the people that they have the right to communicate and cling on and that we'll do that at our expense? Do we tell the people all across the community that they have the right to pay this off, the debt off over 18 months, $25 a month? To my knowledge, many of our clients, whoever their management company is not certainly ever being misleading, but they're not getting into the nitty-gritty of what the statute requires on a mass scale. Do you agree with that, Tim? Just for that reason, they're like, well, if we do a special assessment, go ahead.
Yeah, you certainly don't have to legally, and I don't think it's a great idea to pour the whole law out on them, 17 pages worth of things. But I have seen in our own community where Dave and I both live and on the same street, as a matter of fact, but they sent out a letter saying, here's all the, there's a lot of changes and there's a lot more administration going on prior to these things ever getting out of our office as a management company, and therefore, get ready for your assessments to go up, is kind of what the letter said, if I remember correctly. And they said it's all due to this new legislation. So I think it's okay to notify people that, hey, there may be, we're required to post things on your door if you're delinquent, some general information like that, so that they don't come back, like I said, and say, oh my gosh, what are you guys doing to us? I think that's okay to do. I just don't think you have to get really deep into it.
Absolutely. And we'll talk about that more later on in the presentation, but just a general consensus, Diversified's recommendation is to not knock on your neighbor's door and tell them that they owe that additional funds. Trust your collections process, and we will make sure that all of the owners are in compliance through our normal practices. So what can you do to save costs for your community association and for your owners? As we all have discussed, this is going to be an additional cost for the homeowners and for the associations as well. So you want to encourage communication and educating your homeowners. Like Tim just said, we can do email blasts, we can do community newsletters. We want to always encourage our homeowners to be in attendance during the board meetings. We also have found that by the owners signing up for automatic payments through the association's portal, that has significantly reduced the cost for the associations. The owners are automatically paying their bills, and the associations aren't having to send out any of those additional statements that are required per the new law. And another fantastic thing that we found, that overall collections have improved through all of our associations, because the owners actually know what's going on with their account. They're not just getting a paper bill and not looking at it. So they're actively aware of what's going on with their account balance, and they're taking care of business just like the boards are and the associations are, and the collections overall have improved.
And I think the two biggest reasons we've seen collections improve are, one, the monthly delinquency statements. There's the requirement to now send homeowners who are delinquent, whether it's violation fines, interest being accumulated on their account, a statement of, hey, you owe the association. And it just creates an environment where we're over communicating, which is a positive of the new bill. And then the posting at their unit, of course, that's creating an environment where we're over communicating, hey, you owe your association and we're coming to your door. So, there's pros and cons, but one pro that we wanted to pass along to our boards is that collections have improved after the bill was passed.
And Diversified is doing everything in our power to make sure that we're ensuring that sense of community for all of our associations.
Okay, switching over to covenant enforcement.
Oh, do you want me to go through the chat, or are we going to save that to the end?
Oh, up to you guys.
We'll save it. We'll save it to the end because Brittany's answering most of those.
Okay.
Oh, gotcha.
I apologize. I wasn't reading the chat room, Dave.
No, I have it open. It's good. Great questions. So one of the things about covenant enforcement is the statute divides every covenant enforcement issue or every covenant violation into one of two categories. something that threatens the public safety and health, and something that does not. For a covenant violation that violates the public safety and health, and that is not defined, we don't know all of the things that might violate the public safety and health, we have to give the owner a 72-hour cure notice, an opportunity to cure, and that 72 hours runs from basically when they receive the letter. That sounds great to some people. You know, for us, for me, if it's something that violates the public safety and health, I don't want to give somebody 72 hours to keep doing it. You know, we have people throwing whiskey bottles off a 40-story balcony. We have people throwing couches off a 10-story balcony. We have people pinching lifeguards at the pool. I don't want to give them 72 hours to keep doing that. And if they stop doing it within that 72 hours, it's not believed to be a violation. That was a miss, I think, in the statute. And I don't think, but that's what it says. So we have to be mindful of how we deal with some of these safety issues.
That is an understatement.
If it's not cured within the 72 hours, you can fine every other day. And there's no limitation, in my opinion, on violation fines for violations that threaten the public health and safety. So, you know, you could still have, and I've written some really big fines, especially for some of our really high-rise buildings, because, you know, if somebody gets a bottle dropped on their head from 25 stories, they're dead. And we don't want that to happen. And we want there to be a significant penalty monetarily, not just the criminal potentially liability and otherwise. Yeah, there we go. So for every other violation, it starts with a 30-day cure. They have a 30-day cure period to stop the violation. And within that 30-day period, if they provide us an email or a letter saying I cured it, and they provide satisfactory visual evidence that they cured the violation, it's deemed cured and we stop whatever we're doing. Now we will go out after that and find out whether or not they actually cured it. But the statute says when we get that notice and satisfactory visual evidence, we are supposed to believe that it's cured until we go out and find that it's not.
So you can see you can see how that's going to be a problem for a lot of things. We have a community that has miles worth of private road. They'll never be able to find somebody for speeding under that theory because even if it's a 72-hour thing, all they have to do is say, well, my car's in the garage now. I'm not speeding anymore. You gave me 72 hours to cure. Here's a picture of my car sitting in the garage. I'm no longer speeding. Trash toters, right? If they're out, I think that you'd be hard pressed to say that's a safety issue. So now they got 30 days. All they have to do is take a picture of the curb saying, my trash toter is no longer there and it's deemed cured. They can bring it back out the next day and start another 30-day period. So, you know, I think that was another big miss of this law is that these lawmakers didn't think that there was anything other than some sort of house paint or weeds or something like that. And so I think that was a huge miss.
I agree. If the owner doesn't provide visual evidence of the cure within the 30 days or after the 30 days, any time up to the expiration of the 30 days, the statute curiously says you have to inspect it within 7 days of the expiration of that 30 days. Why it has to be within 7 days is beyond me. That's what it says. If after you inspect within that 7 days, it has not been cured, then you have the ability to fine them and another 30-day cure period starts. So we're now 67 days out before we can, potentially bring a lawsuit, which is fine. That's not really a change for non-public health and safety violations. In fact, a lot of times associations would have a 90-day trigger for referring out a covenant violation that had not been cured. So it's not necessarily the issue of the timing that I have a challenge with. It's, they send the visual evidence of the cure, so we think it's cured. Then we find out it's not cured. Or if they don't respond, then we have to go out within 7 days. What if we go out 9 days later because it was over a holiday or something like that? These are the types of things that people fight over, and we don't want to fight. The only thing that we probably will all agree on is the less fighting with lawyers that associations have to do, the better off the community is. So there's some things that I think will be addressed if a cleanup bill is introduced.
Yeah, and I just want to reiterate on that. Like, we at Diversified don't want to fight with the homeowners or the board members. And I know every single board member on this call does not want to fight with the homeowners either. We all want our associations to be the beautiful communities that they are, and we want our associations to be in compliance, and the homeowners just need to be educated. So thank you.
Yeah, awesome. Okay, let's see here. So, so there's I forgot the other slide. So the reality is if they cure it, we have to send them a letter. Yeah, this is okay. So we can start finding them after the first 30 days for a non-public health and safety violation. We can find them through the second 30-day cure period. And after the second 30-day cure period, which is roughly 61 to 67 days in length, then you could sue them for a court order asking them to fix or stop whatever they're doing. Cannot foreclose on fines. That's under the statute. That's, I think, a direct consequence of Green Valley Ranch. If you levied violation fines for an outstanding covenant violation, those cannot be part of your foreclosure case. And you can't charge someone to tell them how much they owe. And we get a few people here in our office. Every month they want to pay off. How much do I owe? How much do I owe? And it takes time to give that payoff, depending on who it is and what's going on. But statutorily, you can't charge for that payoff. We would like not to charge for the payoffs, and we typically don't. But every once in a while, we get a repeat offender who wants us to do their bookkeeping. So statute says we can't charge for that. So once the owner cures, then you send them a letter validating the fact that they cured it, saying that they will no longer be fined, and that letter must contain the outstanding fine balance. And that typically, from my experience across most management companies that we work with, is a custom letter, because I haven't found most of the mainstream homeowners association management software that has this ability to run that report and plug it into a pre-printed letter. So that has been doesn't sound like a big issue, but I have found universally, or almost universally, that software has not been able to bridge that gap yet. They're working on it, is what I've been told. I don't know what your guys' experience is in Diversified, but that's caused a bit of a wrinkle. Unless you just do the letter by hand, and that's fine. Fine for you to do it, that is.
And thankfully, our software has provided the option to be able to provide a breakdown of the balance the homeowner owes, including the violation fines. And so,
awesome.
Thankfully, yes.
Awesome. Okay.
Okay. So what is Diversified been doing behind the scenes to comply with the new covenant enforcement laws? As Kelsey mentioned, with collections, we've drafted new covenant enforcement policies for all of our associations who have to comply with this new law. If you have any specific questions about your covenant enforcement policy, reach out to your manager and they can provide you a copy. For the most part, they are very similar across the board. And our team has been working really hard to create new templates for all of the new requirements. For example, homeowners that have corrected a violation now get a letter being sent saying, hey, we see this, you've corrected the violation. So again, we're over communicating, but it is more communication to the homeowners and more costs. Some of those costs can be, the majority of those costs, I should say, can be passed along to the homeowner. Refer to your governing documents, because some governing documents are very specific of costs being passed along to the homeowner. But for the most part, those costs can be passed along to the homeowner, but it has taken additional oversight and from our managers.
Right. And these costs are so Diversified, and the association is in compliance with this new law. This isn't something that we have any wiggle room on. We are required to make sure that we are following this new law from every single bullet point from A to Z. So thank you, Casey.
So again, it was really important for us when we were speaking with Moeller Graf and Kelsey and I were brainstorming to show the human aspect of all of this. There's a big human aspect to protecting your property values, protecting your community, and creating a sense of community. As a board member, it's a huge role that you play, and you play a role as a leader and someone who is on the front lines when it comes to communication, and it can be difficult at times. So we wanted to shed some light on what we're seeing and what recommendations we have to make your jobs easier as volunteer board members. First, treat everyone fairly. It's so important that you are enforcing your rules consistently across your community. And, I always say, trust your gut when it comes to whether you're doing the right thing, or you may be listening to a homeowner who's being too hard on the rest of the homeowners. So it's so important to treat everyone fairly, and the board has a fiduciary duty to do that. Keep in mind, you can only enforce HOA matters. So anything regarding state law, we get calls all the time of someone stole packages from my front porch, and there's been theft in our community. Your governing documents only allow the HOA to enforce HOA matters. So it's really important that you understand that hierarchy. And if you have any questions, your community manager will be a great resource to ensure that you're enforcing your governing documents and that you're not enforcing state law or federal law. It's important to be fair and make sure you're complying in that way.
So your association's governing documents are the rules for the association, and we can enforce that, but we cannot enforce the state laws outside of this 1137 new legislation.
Avoid unenforceable rules. So what we mean by unenforceable rules, I mentioned it, anything that conflicts with state law. So if one of your homeowners is wanting to install solar panels, there's law out there that requires the HOA to work with the homeowner to be able to do that. So again, lean on your community manager, but it's really important that your rules are being consistently enforced and that they're not conflicting with the state or federal law. Be reasonable to promote compliance. David and Tim spoke to this. These new laws are so rigid, and from a homeowner's perspective, we always try to put ourselves in the homeowner's shoes. From a homeowner's perspective, it feels uncomfortable that the HOA, when you've left your trash can out or you haven't picked up after your dog, you're getting a certified letter that says, if you don't comply, we're going to move forward. And it also speaks to, here's all the threatening things that the HOA can possibly do. And that's all required by law. When our company was founded 17 years ago, it was always important to us to take a friendly approach and a human approach to HOA matters. Our industry has a bad reputation for that reason, because we are those people enforcing the rules. And it can be a lot for your homeowners. Yeah. And so in our experience, being reasonable and understanding that your homeowners have lives outside of their HOA goes a long way. And being understanding and hearing people out and having face-to-face conversations, helps educate your homeowners and helps them understand the rules and be compliant.
Living within a homeowners association is all about building a sense of community. And that's why you need to have that open communication with everyone within your community when it's possible. So you need to make sure that you're educating your homeowners.
Great segue, thank you. And that can be done from email blasts. We've had many of our associations draft email blasts to send to the homeowners. Hey, there's new laws out there and things are changing, and here's what that means. When we're on the phone with the majority of our homeowners, they just don't understand the new laws. We live and breathe it every day, but they don't understand the new requirements. And it's so important to educate your homeowners, and it helps them understand that there's a bigger picture reason to every violation letter you send, and goes a long way. Utilize our friendly reminder notice. So as David mentioned, we've been really focused on how do we enforce these new laws in a way that resonates with our homeowners. And because they are very rigid and require us to send things certified mail, require us to post collection notices at the door, require us to re-inspect the unit, homeowners don't understand this rigid approach that we're having to take. And so as a result, our team has created a friendly reminder notice. It's outside of your regular covenant enforcement policy, but it's a letter that we've created that helps educate homeowners on, hey, here are the rules. We understand that you might not know them. We want to be reasonable. We're human beings on the other side of all of this who want to protect our community and do the right thing. And it doesn't go out certified, it goes out regular USPS mail and email, but it helps homeowners first understand, oh, okay, I didn't realize I, couldn't leave my trash can out the day after trash day. And so that's the biggest thing we see is homeowners don't realize the rules that the community has in place. And it's a great way to create an environment where, hey, we're cool people, we want to do the right thing, and we want to be reasonable, and this is us making an effort to do that.
Yeah, and that's how we save the cost for our homeowners and our associations, because 97% of our homeowners will take that friendly reminder notice and be like, okay, sorry, I won't do it again. And there won't be any continuation behind that because they will continue to follow the rules of the association.
And I see a few people in the chat speaking to renters. Renters are some of our most difficult people to deal with because they don't have as much of an invested interest in the community. They're not homeowners, and our goal is to protect property values. So it's all about communication. And in our experience, half of owners do educate the renters on the rules, and half of them don't. And so a big role that we play as the management company is trying to get in front of the renters and educate them as much as possible. And a good way to do that is by being reasonable and friendly, and then knowing our goal is positive, and we have everyone's best interest in mind.
Right, and I just want to add to that, like, the board members need to put themselves into that situation. Like, I'm sure every single person on this call has rented a home in their life. And when I was a renter, I did my best to follow the rules. And we need to give everyone a little bit of grace because every single person who's in that home wants to do the right thing. And just because they're not the owner of that property doesn't mean that they're trying to break the rules just because they're not educated as much as the homeowner would be.
Yeah. So as we move forward with covenant enforcement in this new bill, we're summertime is going to be here before we know it. Our recommendation is to get aligned with your manager on the top 3 covenant violations you'd like to focus on. Because there's these requirements to re-inspect every violation, to provide photo documentation, it's going to be more difficult to enforce things like trash toters and dog waste. So get aligned with your manager on what are the 3 things that we'd really like to see improved in our community. And that'll help your manager, 1, communicate with the homeowners better and be more successful. And then our recommendation is to focus on larger matters that protect the appearance of your community and protect property values. David and Tim mentioned this, things like trash toters are going to be harder to enforce. And it's something that the bill didn't address that's a real thing, people leaving their trash toters. So if your trash day is on Thursday and you're strictly enforcing trash toters being out at 8 a.m. on Friday, it's going to be more difficult because if someone provides a photo of, hey, my trash toter has been put away, that's it's more difficult to enforce. So focus on larger matters that protect the appearance of your community and property values. That's really your role as board members. And we take that very seriously at Diversified. We talk all the time about we're protecting people's property values. It's the biggest investment of people's lives. And there's emotional ties to that too. So things like architectural approval concerns, someone has painted their house pink, those are the things that the board should be focusing on. Homeowner required upkeep, painting, fences. What's maintaining the longevity of your community to overall maintain your property values?
Thank you, Casey. Good job. Throwing the ball over to Moeller Graf.
So one of the things that I didn't make clear is there's a couple numbers floating around. And I didn't say this. There's a $500 limitation on violation fines for a non-threat to public safety violation. So you can only charge $500 for that violation. There's no limit for violations that constitute a public threat to public health or safety. The 8% is a limitation on the default interest rate that the association can charge on a delinquent account. Part of 1137 was to minimize excessive foreclosures, and they certainly did that. Have to comply with the collection requirements. You have to give the owner an 18-month payment plan for any delinquency, whether it's a foreclosure or not. And as long as they pay $25 a month, they're within that payment plan.
And that 8% also is, you know, it's so that whether it's a fine, whether it's just you're delinquent on assessments, whatever the amount, whatever reason you're behind and owe money to the association, that's where the 8% comes in. So it doesn't matter whether it came from covenant enforcement or not.
Awesome. We'll move to the next one. They expanded the small claims court jurisdiction to allow owners to basically sue associations to get their relief in small claims court. Haven't yet seen that shake out. Associations can't use attorneys to file as plaintiffs in small claims, but they can still use legal counsel to defend in small claims. We'll just see how this, I don't have a problem personally with small claims for some of the things, but if we're talking about a determination as to who maintains what on a property, it can be a multi-million-dollar decision, and I don't think it's the type of thing that should be decided in a 20-minute trial in small claims, but that's my opinion, and the legislature didn't take that into account. I'll take the next slide. This is just, be careful. As all we're saying, this is a huge change to the way associations do business with respect to collections and covenant enforcement. It's going to cost money. It can be abused. I think it's still too early to know whether it will be abused. I'll take the next slide, please.
So this is where Casey and Kelsey, I don't know if you want us to continue on to the other things that came up in the last legislative section, or if you want to go straight into question and answer. Up to you guys on time.
I don't think it hurts to briefly reiterate some of the new impacts of the law.
Okay.
Proxies are good for 11 months. If you're going to close your common elements for repairs, you have to, for more than 72 hours, you have to post notices. There's some additional burdens that you have to follow when you're closing common elements. Towing is made a little bit more difficult. That's mostly a problem for the towing company, but if you have towing in your community's parking lot, for example, you're going to have some new signage, and the statute's very clear that you can't tow for an expired registration. So that's mostly a towing company problem, but for communities that live and die by their towing for their common area parking lots, it is a little bit more of a pain. So we got that one. Towing, proxies, 11 months.
Public right-of-ways.
Common elements. Oh yeah, this is the sleeper problem, right? The sleeper bill, which was very innocuous in its language. It said you basically can't enforce public rights of way, how owners use the public rights of way. So if you're on a street a community that has public streets, you can't enforce, I don't think, anything on them. Trash toters, parking of RVs, parking of big rigs, anything. And that, again, I think that was also a overbroad brushstroke in the legislature. We have a lot of communities that have covenants that say, you know, you can't park on the public street in front of your home. And before this law took effect, that was legal. There's only 2 cases in the US that stand for that proposition. But if you have public rights of way within your community, whether that's public streets or otherwise, be very careful in enforcing any behavior on those.
So a lot of that is getting pushed back to the, you know, to the municipalities, whether it's the city, the county, state, whatever. I think they're seeing a lot of pushback now for these campers and boats and trailers being parked out there. Since the association can no longer do anything, people are calling them. So we'll see what happens, whether they, you know, whether they throw their hands up and say, okay, we give up, we'll let the associations do this again or not.
Yeah. So we want to take some questions, or 5 minutes? I can go at the bottom up, or I can go, I'm trying to see. I know Brittany Murray has been feverishly responding to these questions in the chat.
Yeah, there's a lot.
Yeah, thank you, Brittany.
Let's see. Jim asked a question. Does the $25 a month have to be in a mutually agreed payment plan? Or is it sufficient for homeowners to pay $25 each month without acknowledging what they are doing? That is an awesome question, and you must have been a collector in your past life.
That's a great question, yeah.
I don't think it's 100% certain how this goes. If somebody started paying $25 a month and they wouldn't sign a payment plan agreement, I probably wouldn't default them, just because I think it would be, I think we're getting there. What we say is that we got your $25, we'd write them a letter and say, we presume that you will pay at least $25 a month for the next 18 months or 17 months or whatever. And in the event, we would write them a letter back saying you're in a payment plan. And I wouldn't necessarily ask that to be signed, because they won't sign it. And then they'll say, well, I didn't sign your letter, so therefore I'm not in a payment plan. I would just say, we got the $25 a month. We'll expect it every month on or before the 10th of the month. And if you, in the event you miss 3 of them, we're gonna default you. Great question.
Yeah.
Boats and campers parked in the community streets. Yeah, I mean, there's a couple comments on the city enforces the public streets. They do, but they weren't the sole enforcer of public streets until this law took effect. And if the covenant said you buy a house here and you're not going to park in the public street in front of your home or wherever, then historically that was enforceable as a contract between you and the owner who agreed that they wouldn't do that. Didn't apply to people who were not owners, because we didn't have that contract of the declaration to enforce against them. But yeah, I mean, Highlands Ranch, to my knowledge, enforced parking on the public streets for 30 years. It's 30,000 homes. So there was a lot of community frustration that they could not any longer regulate public rights of way in any meaningful manner. And yes, some municipalities are very aggressive in doing that. Most right now, to my knowledge, are overwhelmed, and we're not seeing the same curb appeal that owners had become accustomed to.
Steve Hoffman says they have private streets. Can they still enforce their parking rules on the street and the driveway? Yeah, the answer is yes. You can. You just have to follow those new enforcement rules, which is 30 days, right? So after, on the 29th day, they could take a picture that their RV is no longer there, and it's deemed cured is the language in the statute. Then they could just throw it back out there again the next day, I guess. So, you still have to follow the process, but yes, it's enforceable on private streets.
Yeah, and some of the counties will have, and I don't know about El Paso County off the top of my head, but they'll have a GIS map that can be accessible on the internet, and you can sometimes overlay what the county or the city says is their public rights of way. If there's a close call, because sometimes we're not always sure, is it a public right of way or is it not? And it's always nice to take a screenshot of what the city says it is before we would send out a notice on that. Let's see. Where can associations find what the legal fees are? Well, that's a good question. The lawyers would tell you, your lawyers would tell you what their legal fees are. We send out a statement every year about what our schedule of fees is for fixed fees and hourly rates. There's not a limitation right now. There's talk about attorneys' fees being limited. What one proposal that I heard, not from a legislator, was we're just going to cap attorneys' fees at $750. And I said, well, what if the association spends $750 and the violation is not complete? And they said, well, then the association can't charge anymore. I said, well, who's going to continue to enforce that? And what if it's something that's dramatically affecting the community? Well, the association is going to have to spend the money out of its common fund or stop enforcing it. Well, everybody moved in with the expectation that the covenants would be enforced in a reasonable manner. It's just these conversations to me sometimes become a little otherworldly. But questions about legal fees would be directed either to your management team or to the attorney. Let's see. One question I thought was really interesting is making owners prove that they've given the rules of the community to the tenants. And we see sometimes in rules, the owner must provide this to the tenant. I've never found a great way to enforce that. What I usually say is, the owner is the responsible party for the tenant's rule infraction. And I don't really care if the landlord provided the tenant with the rules. I'm going to hold the landlord, the owner, accountable. Because if we say, well, the tenant has to be provided these rules, and the tenant can prove that the landlord owner didn't provide them, is that a defense to the association's request that they comply? I don't think it is, but I've had people make that argument. So there's no right answer. I think there's a great reason that you would provide tenants with the rules, which is that they know what they're doing and what's expected of them. I just don't always personally make it mandatory, because then they say, well, I didn't get the rules, so I don't have to comply. Not a huge issue, and I wouldn't die on that hill either way. Let's see, questions. Some violations are cured but cannot be cured. That's a good one. Any way to cure it? Yeah, so and in some of our, Cindy, that's an awesome question. Some of the covenant enforcement policies I've written, and we're not sure if it's entirely enforceable, because the statute says they have 72 hours or 30 days to cure, or 60 days to cure. But sometimes I've said, in weird cases, especially when there's a threat, like dropping whiskey bottles off a 40-story balcony, say, certain violations of their very nature cannot be cured, and they occur within a period of second or two, and imminent bodily injury or death may occur, and we're going to deem that those violations cannot be cured, and therefore there's no 72 hours. We're going to sue you, or we're going to fine you. Hasn't yet gone to court. I haven't yet, thankfully, had anyone drop a whiskey bottle since I've written that for one high rise. But yes, we've written some custom language. We would be cautious in not allowing people to cure unless someone's life depended on it, just because it might put us testing this case, and we don't want to test case with an appeal for any of our clients if we can help it. But every once in a while, I would write that in, just because we can't have people dying. And people do weird things on Friday nights when they're out on, in a party on their balcony, and we just don't want people dying. Let's see, what else? Okay, did we get anyone have a question I want to type in? No, I think we're at time. I want to be respectful.
Yeah, I think we're probably at time. I don't know when Casey and Kelsey wants us to.
They said 9.
Stop talking. 9?
Yeah.
Is it 9? 9 sounds good.
We're going to be here all night long. No, I just want to, again, thank you guys for your support for Diversified. You are such a complete resource to us. We appreciate your continued partnership, and having you guys be here, we can't thank you enough. And for every single board member on this call, we wouldn't be here without you. So thank you for being here for tonight's call.
Ditto to what Kelsey said. Thank you for your partnership. We couldn't do what we do without you. We have a team of great people who really care about the communities that we manage and want to do the right thing and protect your property values. So we appreciate your partnership. It's key to our success. And thank you for taking the time to be here tonight.
Yeah, you guys at Diversified are definitely on the cutting edge. And what I would say to board members is sometimes you have to question your sanity for volunteering. It matters. It makes a huge difference, even if you don't always think that it does. And even if your residents don't necessarily agree, I can tell you we've seen communities with bad boards or no boards at times. And the spirit of volunteer service is so important. It's vital to millions of people. So please remember how important it is, what it is that you do. Even if you do that in private, sometimes it's not glamorous work, but man, does it matter.
Yeah, thank you for that service. Absolutely.
And thank you, David and Tim. We're so grateful to work with, good humans like you who also want to do the right thing and protect communities and, just be a positive influence in an industry that's difficult. So thank you.
I think that's the consensus of tonight's call is we are all humans here tonight trying to do the right thing with the cards that we've been dealt. So thank you, everybody.
The legislature is with a lot of, I've taken their name in vain at times. We all get frustrated with this. They're not bad people, the ones that sponsored this bill. We have disagreements on how far we go to protect individuals. We all have to stay calm, I think, and respectful when we talk to our legislators, and we're working to inform them of some of the positions that we see that they may not have seen when they did this, but they're trying, and I think there's going to be a good faith effort to revise this in a way that is palatable. So just want to throw that out there.
Thank you again for your time, everyone.
Thank you.
All right. Thank you, everyone. Have a wonderful night.
Have a good night, everyone. Thank you for joining our call.